That's okay. Thank you. Good morning. Are you Virginia Williams?
Yes, ma'am.
And let's see. Give me just a second to get this close. Judges do one rejection.
Oh, I only did one. I did, Judge. Yes.
Is it the same
Yes.
to run concurrently?
Yes.
The objection may fill in that in.
No, Judge. Sorry.
All right. So Ms. Williams, in cause number 26 DCCR 0218, you're charged with a state felony offense of theft of property with previous convictions. That's from November 25th of 2025. Your indictment alleges you were previously convicted of theft May 12th of 92, and then 3 cases, January 11th of 1994, again, October 9th of 2006, April 13th of 2011, May 2nd of 2012, October 6th of 2014. And then your indictment further alleges that you were convicted of forgery, a 3rd-degree felony, August 4th of 1995, 2 cases on that day of forgery, and then another of securing execution of a document by deception. And then after those were final, you were convicted of possession of a controlled substance, a 3rd-degree felony, December 18th of 2017. Well, what that means is that if you go to trial and you're found guilty and all of those prior, or at least some of those prior convictions are true, you would be facing punishment as a 2nd-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yes.
And I have here, and that's in both of your cases. The second case is 25 DCCR 1430. It charges theft of property with previous convictions, and that one's from August 9th of 2025. Again, with those same prior convictions listed and the same possible punishment range. You understand that as well.
Yes, ma'am.
And then I have a plea bargain rejection that you've signed with Mr. Parker that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty to proceed on count 1 only for an 18-month state jail term in each of those cases that would run concurrently, which means together at the same time. You have every right to reject that offer and have your cases set for trial. I want to make sure you understand that before we go to trial, what your options are and what the possible consequences are if you go to trial. And do you understand all of that? And you want to reject that offer and have your case set for trial. Have both cases set for trial. Okay. I do want to also make sure you understand that after today, I will not accept this plea agreement. This plea agreement is already extremely low for the criminal history. Even though some of it's very old, it is significant. And so and it's fine if if you're not guilty of both of these offenses, then that's what a jury's for. So I'm not trying to talk you anything. I'm just trying to tell you that I'm not going to accept this plea agreement after today. Do you understand? Okay.
Just for the court to where it is that one reason it's been reset is there's supposedly people are going to sign a non-prosecution affidavit. Well, affidavits that she's not the one that did it, and she has got it signed, but it's not notarized. And I told they need to go to the DA's office. So that's the only.
And y'all haven't had anybody come to do that?
No, Judge. I don't think so. This is not my case.
I cannot hear you.
This is not my case. It's for the small fingers.
Okay.
That one's really.
But she has not. No, nobody has been there yet.
Ms. Williams, if I test you this morning, will you have anything in your system?
No.
Have a seat in the jury box. We're going to double test that before I reset it for trial.
I'm going to go check in.
Okay. Mr. Rojas? Mr. Samuel? Mr. Wasserstein? Good morning. Guadalupe Reyes? Good morning.
On the way up. He understands what's going on. Judge, I have my assistant going to help to translate. We're going to reject the offer today.
Okay, you need to do that in writing. There's a plea bargain rejection on the tablet, and then I'll call it up, and by the time she can be up here and help me go through that and make sure he understands all of that.
Yes,
Okay,
Your Honor.
I'll hold it.
Go ahead and do it.
All right,
I'm
thank
sorry, we had a little emergency in the parking lot with a different county and a Zoom.
Okay.
So
That's okay. No problem.
he's on
Yeah,
it.
no
We'll
problem.
get it done, Judge. Thank
Sure.
you.
And they can, if you need some help, I'm sure one of the attorneys can.
I probably will.
Okay. Mr. Burbank, you've got Tiona Hughes. I'm sorry.
Thank you.
I'll hold it. What about Crystal Robertson, Mr. Burbank? I'll hold it. Let's see. Ms. Simmons, are you handling Austin Tebow?
Yes, Judge.
26 DCCR 1102 on Austin Tebow. Good morning. Good morning again. Good morning, sir. Are you Austin Tebow? And this is cause number 26 DCCR 1102. Mr. Tebow is charged with publishing or threatening to publish intimate visual material. And what is the announcement?
Yes, Judge, I believe this is Mr. Gallagher's first setting. We're just asking for a reset to work the discovery.
All right, any issues? I'll just do a normal reset, Mr. Tebow. That's about 30 days or so. Make sure you get in touch with and visit with your attorneys before the next court date. So you can go over all of the discovery that they've received, and we'll see if we can get an announcement. All right, you're free to go. Thank you. Mr. Kimler, you've got Charles Beard. Okay, here with us.
Yeah.
So should we just bring him over tomorrow? Or do I do that at large? I guess in this case.
I
think it's a new case.
didn't check what it was.
I'm not sure.
Can you tell when you look at it? What? Okay. This is Miss Malfino's case on Charles Beard.
I think his mother is here.
His mother is here.
We just need to see why he's in our, he's in jail. So we need to, I'll just need. It does say parole violation, not a new case. You don't have, do you have any notes or from Ms. Malfino that shows any new case?
There is an evading and a theft from September that appear to be pending.
Mr.
He is on parole through 2036, so
Those are misdemeanors that are already
it
pending.
doesn't say here on it.
Can you tell if he also has misdemeanors? Oh, so there's a new case as well. Burglary of a habitation from June 25th
We don't have that yet.
and June 23rd for burglary of a building. And March 1st for possession, all while on bond for this case. So I'm going to find that he is at large without proper bond in this case and reset the bond at $100,000 in this case. All right, Evelyn Odom, so sentencing.
She's present.
Judge, we had agreed on a misdemeanor reduction for her to do 30 days. Today's just her.
Actually turn herself in.
There's no warning.
Got it. Good morning, ma'am. You are Evelyn Odom. And Ms. Odom was previously here in cause number 26 DCCR 0403, entered a plea of guilty to a lesser offense of Class A misdemeanor evading arrest or detention. And I reset it for sentencing. Ms. Odom, have you been arrested for anything between when you were here to plea and today? All right, then any reason not to go forward?
No, Your Honor.
All right, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of evading arrest or detention. Sentence you in accordance with your agreement to a term of 30 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody previously on this case that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. All right, good luck to you, ma'am. You can go back with the bailiff. And then you've got a sentencing, Mr. Kimler, on Michael Sarant. Good morning. Are you Michael Sarant?
Yes, Your Honor.
And Mr. Sarant was previously in court, entered a plea of guilty in cause number 25 DCCR 1691 to the third-degree felony offense of evading arrest or detention with the use of a vehicle. I've received that pre-sentence report. Has everyone had an opportunity to review that report?
I have, Your Honor.
Yes, Your Honor, we have.
Any additions or corrections?
None from defense.
No from the state, Your Honor.
All right, Mr. Sarant, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, however, you will follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. There is a recommendation for some spinal tap treatment. I didn't really see a lot of issues with that. So what I'm going to do is just order an assessment first, and we'll have a mental health assessment done. If there's some issues that need to be addressed, then whatever that is, if there's any, you'll be required to follow whatever treatment recommendations. You understand?
Yes, ma'am.
All right. If you do everything you're supposed to when you're on this probation and follow all of the rules successfully, then at the end, this is the case will be dismissed. It's a great opportunity. You don't have a felony conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and you could be sent to prison for between 2 years and up to 10 years. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork, so just listen for her to call your name.
Yes.
All right, good luck to you, sir.
Thank you.
Mr. Lewis, you have Marvin Davis. Morning. How are you?
Well, all right. this morning.
Yep, it's Monday.
I know.
Good morning, sir. Are you Marvin Davis? And this is cause number 26 DCCR 0754. Mr. Davis is charged with injury to a child, elderly, or disabled individual. What is the announcement?
Judge, we've gotten an offer from the state that I do need to go over with my client some more. Also, he's involved right now with his payment plan and everything going on with CPS. So part of that is that we're trying to let him get a little further down for us to complete some of those classes
Sure.
before we proceed. So we're asking just for one reset.
Right. Any issues?
No issue, I see, Your Honor.
All right, I'm going to reset your case, just a normal reset. It's about 30 days. Make sure you follow through with everything on that safety plan. That's only going to help you in this case as well. All right. Stay in touch with Mr. Lewis. He'll let you know when your next court date is. All right, you're free to go. Lance Charbino, Mr. Lewis.
Morning, Your Honor.
Good morning. You're Lance Charbino.
Yes, ma'am.
And this is 25 DCCR 0096. Mr. Charbino is charged with credit card or debit card abuse. And what is the announcement?
Judge, we're asking if we can set this for a plea for next week. He will be able to have that restitution by tomorrow. Should be, so we be able to have that paid before we come back.
Any issues, Mr. Nichols?
That's fine, you
All
stand.
right, we'll reset it 1 week for a plea. So it'll need to be taken care of next Monday. All right.
Thank you, Judge.
And then Mr. Mitchell. Did I see Mr. Mitchell? I thought I did. Let's see. Robert Simon, Mr. Rojas. So Mr. Simon was ordered to wear a drug patch in all 3 of his cases. That was an order of bond condition. And I got a notification from Johnny's that he went into the office without a patch on. You need to have a seat in the jury box. We're gonna have you tested this morning. Then we'll discuss why potentially.
Judge, I have a hearing at 11 on Bonilla.
Okay.
I've come to an agreement with the state where we're going to plead the misdemeanor and everything that down here is going to be dismissed. The probation's already expired down here anyway, so.
Okay, there weren't any witnesses.
Judge, he's on probation for a misdemeanor. It's a new misdemeanor allegation. We've got it worked out. So we're
Okay.
gonna need to have a hearing.
Okay, all right. I guess just, yeah, you go down there and take care
We're
of
waiting for
it.
Judge to call us down there.
Okay, sounds good. Let's see, Mr. Samuel. Just wanted to see. He was in and then he's out. Well, I called him first and he asked me to hold it, so when.
Court did, I didn't.
That's what happens. Coming back around to the front again. Mr. Kelly on Matthew Pham.
Yes.
Good morning. Are you Matthew Pham?
Yes, sir.
And this is 18-29698. Mr. Pham has a motion to adjudicate on a probation filed. Underlying offense is theft of cargo. And what is the announcement?
Your Honor, I'd like a little bit of time, please, to figure out what's going on with these misdemeanor allegations. Those are also old, and those may resolve, which could help us resolve this. We're also potentially able to make a pretty significant payment towards the restitution. I've informed the state of that this morning, and I'd like to see if we had a little bit more time. Also aware of how old this.
So this motion was filed back in 2022 and we haven't had any contact with Mr. Pham since then. Is that correct?
That is correct.
Okay, and it was pled down?
It's worded strangely in the motion, I think, but yes.
Mr. Smith, any issue with it? So it was pled to a third degree.
It's still a third degree. I believe it, with the amount was more than that, but maybe restitution was paid up front or something. I'm not exactly.
Restitution was ordered in the amount of $99,999, and it was pled, I guess, from a second to a third for a 10-year deferred back in 2019. And the motion was filed in 2022. I'm going to reset it one time. Mr. Pham, you need to stay in touch with Mr. Kelly because I'm not going to put it off longer than about 30 days or so. All right. Okay. We'll see you back in 30 days.
Thank you, Judge.
Thank you. Mr. Wasserstein, do you have your, and do you have the interpreter? All right, Guadalupe Reyes.
The courtroom fell silent as a repeat theft defendant made a decision that could change her future forever. Regina Williams was facing 2 felony theft cases, and the judge carefully reviewed her long criminal record, which included multiple theft convictions, forgery, deception, and drug-related offenses stretching back more than 3 decades. Because of those prior convictions, a guilty verdict at trial could expose her to as much as 20 years in prison. Despite those risks, prosecutors offered what the judge described as an extremely lenient plea agreement, an 18-month state jail sentence on each case, to run at the same time. But instead of accepting the deal, Williams chose to reject it and take both cases to trial. The judge then issued a serious warning. She explained that once today's hearing ended, the plea offer would no longer be available. She emphasized that the agreement was already unusually generous considering Williams' extensive criminal history and made it clear the court would not accept the same deal later. Williams' attorney responded by claiming that witnesses were expected to sign affidavits stating she was not the person responsible, although those documents had not yet been properly completed or submitted. Before ending the hearing, the judge ordered an additional drug test before resetting the cases for trial, adding another layer of scrutiny to an already high-stakes case. Now the plea deal is off the table, and the next chapter will unfold before a jury. If convicted, the consequences could be far more severe than the offer she walked away from.